Hello and welcome to The Big Picture. I'm Teena. The Union Cabinet on Wednesday approved the continuation of over 1,000 fast-track special courts to ensure faster delivery of justice to victims of sexual offences as a centrally sponsored scheme for a period of another 2 years. Now, these also include 389 exclusive POCSO courts to expedite trial and provide immediate relief to minor girls who are victims of sexual crimes. The continuation of the scheme, which was started on the 2nd of October 2019, involves a total outlay of more than 1,572 crore rupees. 971 crore rupees is provided by the centre from the Nirbhaya Fund. The remaining amount is expected to be provided by the states. Union Law Minister Kiren Rijiju called it a major step towards declogging the justice system. The government says, besides providing quick justice to the hapless victims, the fast-track court mechanism strengthens the deterrence framework for sexual offenders. So how effective has this mechanism been in nearly 2 years of its existence? And how do we need to strengthen it further to ensure swift dispensation of justice? These are some of the aspects that we will analyze on The Big Picture today with two of our distinguished panelists who are joining us on the program. So let me first introduce them to you. I have with me Rekha Aggarwal. She's Advocate Supreme Court. Thank you for joining us on the program, ma'am. And Mr. P.K. Malhotra, he's former Secretary, Ministry of Law and Justice. Good evening, sir, and welcome to the program as well. Rekha ji, let me begin the program today with you. So obviously, time-bound justice to victims of sexual offences, this was one major concern. In fact, it continues to be when we talk about justice delivery in our country. And towards ensuring swift dispensation of justice, the fast-track court mechanism has been a welcome step. Now, this dedicated court machinery to expedite trial in cases of sexual offences has been in existence for 2 years. It has now been extended for another 2 years. Help us understand, has there been any change when it comes to delivery of justice, especially for sexual crimes?
Teena ji, I go back to what I studied in law school, and there was a statement that we learned that justice delayed is justice denied. And at the same time, the constitutional framework also provides that every person has a right to try to prove himself that he's innocent till the last court. That is right from the district court till the Supreme Court. And even after that, he's got two more opportunities available to him. That is to file a review petition, a curative petition, and after that, even apply for mercy to the president. So the courts, the judicial system has to balance both the things together. On one hand, we have to provide for justice to the victim. And at the same time, while providing justice to the victim, the judicial system has to ensure that in the haste to provide justice to the victim, we do not deny justice to the accused also. Yes. So this balancing act has in fact caused a lot of delay in the final disposal of the cases. And as we see in the scenario in the Indian context that we see, that our courts are chock-a-block with cases. There are thousands, or maybe if I can even use the word lakhs of cases which are pending adjudication before the courts, whether it is civil courts or whether it is the criminal courts. When it comes to the criminal cases which are pending, of course, there's a big feeling of angst over there, both for the victim as well as for the accused. As a lawyer, I cannot take the side of either, I say that I'm only for the victim or I'm only for the accused. As a lawyer, and then later, I think probably as a judge also has to see that, one does not kind of, tilt the balance in favor of either of the sides. So the balancing act has to be there. And as they say that the law is blind, we see the statue even in our films, that is a statue of the Lady Justice, with a patti around her eyes. So with that, object in mind to provide justice to both the sides, one has to ensure that injustice is not done to one side. Absolutely. Now, of course, in the last few years, we are seeing that despite the fact that time and again, very stringent laws are being enacted to safeguard women, I would not like to use this word weaker sex. That is a cliche. I think that we should try to forget that. I think absolutely. The women as well as the children, they need to be protected. And despite the fact that so many stringent laws are being enacted by Parliament, and each law is more stringent than the earlier one. I would not say that the earlier law of Indian Penal Code was lacking in any manner. Despite that, to fill in the loopholes, to plug in all the gaps, time and again amendments are made. And very recently, in the year 2018, there was a criminal law amendment which has provided that there should be even more stringent punishment in cases of rape where the victim, and especially females, are below 12 years of age or below 16 years of age. In fact, the amendment of 2018 even provides for punishment of death where the victim of rape is a minor girl who is below 12 years of age. And if the girl is below 16 years of age, the punishment can be life imprisonment. So when we have such strong laws, why is it that every day, when you pick up the paper in the morning, we see the headline where we see that a girl has been raped, a minor girl has been raped, or we have children, especially female girls who are being raped, murdered, and thrown away in the bushes. So I think that the lawmakers have done a very, a noble act by extending this fast track court system, for another 2 years. And ultimately, justice not only has to be done, it should appear to have been done.
Absolutely.
And the justice is what which should appear to the every common man. When any common man who's following up a particular case, let us take the example of the Nirbhaya case. Justice was delivered within a time-bound period of 8 to 9 months. Way back in the year 2013, December 2012, the horrific rape case took place. Within 8 to 9 months, the justice had been delivered by the Saket court. But it took so many years, almost 8 to 9 years, until the accused were finally, even though they were found guilty, they were punished ultimately after a very long and arduous trial. So I think that the common man is losing faith in the judicial system, and these fast-track courts will ensure that the dignity of the judicial system is upheld in the eyes of the common man, and the common man has faith and hope in the judicial system. Otherwise, there'll be anarchy in the roads.
Absolutely. And we have to ensure, the government has to ensure that the common man seeking justice does not have to run from pillar to post. Once, obviously they're tormented by the kind of stigma that is attached to such sexual offences, and then to seek justice, they have to run from pillar to post. Mr. Malhotra, what do you think? Because this kind of fast-track mechanism was being sought for. There was hue and cry at the time of the Nirbhaya rape case. We saw in the country, people demanded fast-track delivery mechanism, and this has been in existence for the last 2 years, nearly 2 years. Has there been any kind of visible change when it comes to pendency of cases, when it comes to declogging the justice system?
Ms. Teena, first of all, my compliment to the central government for approving this continuation of the centrally sponsored scheme of fast-tracking special courts for further 2 years. This has been in existence for only 2 years in the past. And as you have already said in your opening remarks, the proposal was for 1,023 fast-track special courts, including 389 exclusively under the POCSO Act, that is the crime against the children. Now, this is not a new trend which has started. If you talk about the Constitution, and Rekha Aggarwal also mentioned about it, expeditious justice and fair trial, both are part of the fundamental rights. And it is the obligation of the state to ensure that the justice system subserves the purpose of the society for which the justice system has been made. But unfortunately, due to large pendency of cases in the courts and the number of judges being not in accordance with the proportionate population which we require for disposal of the cases are taking too long. Even under the existing system, there are criminal cases which are taking 8 years to 10 years to 12 years for disposal. In that scenario, if you have to protect the interest of vulnerable section of the society, probably it becomes imperative that you have to take special measures. And it is not that it has been done for the first time. Since 2000 onward, for the last 20 years, there are many areas in which these special courts have been constituted. And as Madam Rekha Aggarwal also mentioned, it talked about the Nirbhaya case. I was working with the government at that time. I was secretary in the Ministry of Law and Justice when this Criminal Law Amendment Bill of 2013 was passed based on the recommendation of Justice Verma Committee. And the law with regard to rape, voyeurism, stalking, and other was made more stringent, and the procedure were also simplified to some extent. Now, the amendment brought in 2018 by the Criminal Law Amendment Act is a step taken further in that direction. And after that step, because in 2019, again, there was a direction from the Supreme Court that for POCSO, there should be a mandate that there are special court, and in any district, there are more than 100 cases. A special designated court should be made available. So the idea of the whole system was to make justice available so that the victim who has suffered, he gets justice as expeditiously as possible, for which the amount made available under the centrally sponsored scheme is also quite substantial. But unfortunately, what has happened? I was looking at the statistics as per the report given by the Ministry of Home Affairs Committee, Departmental Parliamentary Related Committee in December 20. Out of sanctioned strength of 1,023 fast-track court, only 597 are working.
Yes.
Rest are still not working, out of which 321 are POCSO court. So I think once the government has come out with a scheme, which can be implemented only in coordination with the high courts as well as the state government, I think the state government and the high court should also be equally vigilant to ensure that courts are constituted, infrastructure is provided, and cases are tried as expeditiously possible. But that is not happening, as earlier said also, because of the judicial system which we have, the steps which are involved, in spite of the timelines prescribed under the law, that after filing of the charge sheet, within 60 days under the POCSO, the case should be decided. That is not happening. It is taking much longer because of the procedure delay, and maybe I'll say probably our the councils are also sometime to be blamed because they seek unnecessarily adjournment even in such cases, and witnesses also do not want to come to the court again and again.
Yes.
So but I think that is a systemic changes which is required, and probably on the part of the courts also, it is necessary that they must ensure that the timelines which are prescribed under the law, although they may be called as directory, but they are adhered to. When we don't do that, probably the cases take much longer. Now, Rekha ji talked about the case of Nirbhay, that it was expeditiously decided by the district court, sessions court. Yes, but how many cases are decided as expeditiously as we require? Most of the cases take much longer. So my submission at this stage is that the decision which has been taken by the cabinet, probably it should be implemented not only in letters, but in spirit by the high courts as well as by the state government.
Absolutely.
Even earlier also, when this scheme was sponsored by the central government, state didn't continue with the special courts in other matters also, and they were discontinued. I feel here also, once the center has given a scheme, it should be properly implemented so that the justice, as Madam Rekha also said, should not only be done, it should appear to have been done.
Certainly. Rekha ji, so obviously this is one area that we need to work on. Besides capacity building, what else is required? What is the need of the hour to ensure that fast-track courts, they are meant to be different than regular courts? But even if in the fast-track courts, if the delivery of justice takes 8 to 10 years, what is the purpose? So to ensure that fast-track courts are do not just remain in letter, but also in spirit, what is the need of the hour? What should be done?
I think that besides, starting these fast-track courts and continuing them for another 2 years, if we look at other areas which will make the working of these fast-track courts actually much more positive and, in the right direction. As I just talked about, sensitization. Sensitization has to be done, first of all, in the public. Sensitization has to be done at home. As I say, that real education begins at home. Absolutely. So why not curb the evil, in the bud, nip the evil in the bud, as the old saying goes. So let us start. I think that just making fast-track courts and continuing them for another 2 years will not be the end of the of the problem. The problem still remains. The problem is that sexual violence cases, despite the amendment to the law in 2013, whereas Mr. Malhotra talked about other cases, other offences which have been made now culpable. For example, voyeurism, stalking, the simple thing like eve teasing and molestation has now taken a completely, a different perspective. So despite the fact that we had a Nirbhaya case, very recently we had a Kathua case, we had a Unnao case, all those cases happen, laws are amended, if suddenly we all wake up and, we are all before, in various TV channels, propounding the, the necessity of having a speedier justice delivery system. But yet what happens after that? Just 2 days ago, I think it is just about 48 hours that, in Delhi, we're sitting in the capital. We have the case of a 9-year-old girl who has allegedly been raped and murdered, and that too by a priest, allegedly by a priest who was working in a cremation ground, and the poor girl had just gone to fill water from the cooler over there. So what happened? And she was she was even cremated after that. So just 48 hours ago, that too in the Delhi city, that too in the Delhi cantonment area. So I think that what happens? Why are we not trying to change the society? Why don't we have ways of changing the thought process of the people, the mindset of the people? Why don't we try to make the society more empathetic and more respectful towards women and to children?
Certainly, I think that's the most concerning part, Malhotra, Mr. Malhotra. Because what we are seeing is in recent years there have been stringent provisions in the legislations. There have been fast-track courts to expedite trial. Also, the expected outcome, apart from reducing pendency of cases, is also to strengthen the deterrence framework. So, stringent provisions means it is going to act as deterrent, but looking at the instances that Rekha ji has pointed out, repeatedly we are seeing every now and then gruesome rapes and murders of women, in particular the minor girls that she's spoken about, and it's a worrisome trend. How do we address these issues? Because legislations are one thing, but changing mindset of the people, that perhaps is the biggest challenge.
I entirely agree. Making stringent law is not an end in itself. And by making stringent law, are they really deterrent? I think effective implementation of the law is much more important in addition to making the stringent laws. We find that the number of cases has increased. In spite of these laws being enacted, the number of cases is increasing. And probably people don't have that kind of fear which the law should have. Why? Because of the long delays, that is one. And I think some other areas which immediately need to be attended in addition to the good steps which have been taken by the central government as well as state government, one of them, of course, being the constitution of special courts, is I think we immediately need a good witness protection law, which we lack. If witness protection law is there, if witness also knows that then they will be going and deposing at an expeditious way, then the lack of physical infrastructure in the court itself create a fear in the minds of the witnesses to go and appear when the accused is in front of it. I think there are many areas where in the lack of infrastructure, which we are lacking in the courts, also need to be strengthened. And more importantly, what is happening, even if we are constituting these special courts, from where these special judges are coming. Yes. As on today also, 20% of the posts in the lower judiciary at the magistrate level and district level are still lying vacant. And these are perpetual vacancies. It's not that they have been filled up and then vacancies have come. They are perpetual vacancies. They are not being filled up. You simply constitute special court, but don't fill up the vacant post. That itself increases the burden of the court. If in a court, if suppose you list 100 cases in a day and a judge has a capacity to dispose of only 8 or 10 cases, why he should waste his time on reading other 90 cases? So I think this is number of cases which are to be listed before the court should be limited. Rekha ji, of course, supported my view with regard to this particular aspect that, the judges, when they are hearing the cases, timeline should be mandatory. But you cannot make the timeline mandatory because you can't expect a judge to hear 100 cases in a day. So there should be number of cases which are fixed before a judge should also be limited. In addition to this, the legal processes need to be strengthened. If the trial procedure is the same, which is before a normal court, and the same procedure you are going to have before a special court also, then it is going to be a time-consuming thing. Certainly. So I think the better course is, without compromising with the fair trial, if an easier process and mechanism can be laid down for the special courts, and I emphasize, without compromising with the fair trial, we should consider and work in that direction, so that special courts apply a special procedure, and with that special procedure, the timelines which are laid down can be reduced, so that the timeline which are given in the statute can be adhered to by the court also. I think these are some of the areas of reforms which, in addition to constitution of fast court, the government need to take care of, and if they are taken care of, having the fast track court will be achieved.
Certainly. So a list of reforms that are required to strengthen our criminal justice delivery system. But Rekha ji, how can we also augment technological, judicial and legal infrastructure in the rural areas, in the tribal areas, where also the number of sexual offences is increasing by the day, and there the lack of justice delivery is even worse?
That is a stark reality that we often like to push under the carpet and want to turn our eyes away from the ground reality, that the number of crimes, particularly sexual crimes, which happen in the rural sector or in the backward sector, they absolutely go unreported. Nobody even wants to talk about it.
Yes.
And those are taken as something which happens in society. That is that women, it is their destiny that they have to suffer such kind of crimes. Children have to suffer such kind of crimes, and they should not be make a big ado about it. It's their fate, it's their destiny that they have to suffer such. So as I was talking in the beginning, and I just stated, Teena, I think that until reforms take place at every stage, there are other ways also of sensitizing the society. Let us start with sex education. Let us start with sex education classes in the schools. What about the schools in the rural areas? The government schools, in the villages, the schools that are there, which are almost non-existent. There are schools only for the namesake. There are no students, there are no teachers, there are no infrastructures. The only thing that is for real is that the teacher gets a salary at the end of the month. Because they're government schools and they're going to be paid at the at the end of the month. So I think that let us look at, let us have a holistic approach to the entire problem. Sexual offences against women and children are a reality. They are there in the metros, they are there in the villages, but that mindset has not changed. I'm continuously being harping on the mindset of the people, of the judicial system, of the judges, of the lawyers, of the police, and the society. First of all, the parents, their sons and daughters. Let good education begin at home. Let there be sex education in the schools. Let there be more awareness about the biological processes of boys and girls. Let there be more knowledge that what is, I don't think there should be a fear of law. There should be a knowledge of law. Until there is a knowledge of law that if I commit such and such act, it amounts to a crime, and that this is going to be the end result of such a crime. That this action of mine is not something which I can just get along because I'm a boy or I'm a man in the Indian framework. I'm not on a higher pedestal just because I'm a man. In the Indian system, we do tend to give a little more weightage to the male gender than to the female gender. So therefore, let there be nukkad nataks in the villages, in the rural framework, in the tribal sector, in the backward areas. Say maybe in Chhattisgarh, in places like that, in the Adivasis, the kind of crimes that are taking place only as a matter of right, as a matter of life. That is a way of life happening over there. Rape is not something to cry about. Rape is something which is, as I said, just to be ignored. It has happened and just ignore it now. So that thought has to change, Teena. You have to make women also realize they also need to be sensitized. They need to be made aware of their own rights. They need not have to be always the sufferer who goes complaining to the court later on. So therefore, the constitutional rights which are there provided in the constitution itself, how many people are aware about what is the law regarding section 376 rape? What are the changes that have taken place post Nirbhaya? What are the changes that have taken place in the year 2018? What is the POCSO Act? So the awareness of law is so dismal. The awareness of law is so dismal even in the metro cities. So you can imagine what it must be there in the rural sector. There they don't know anything at all. For there it is something that law is something which is only confined to the court. Vakil jane, kachehri jane. It's like a black box. So therefore, make education a must. Education of sex, education of law, clear knowledge of the law, and sensitization of every person in the society. The parents, first of all. What about the sexual exploitation that takes place in schools? What about the sexual exploitation that takes place in the police stations? How are we going to curb all that? When a child or a woman goes to report a sexual crime at the police station, she can end up getting raped again over there. This is a ground reality. How many cases do we read every day that a woman went to complain to the police station, and this is the kind of problem that she had to face in the police station, and there she again become a victim of sexual assault. So that mindset has to be changed. That rural thought process has to change. Women have to be respected. people should become aware. Let us have more, documentary films. Let not internet only become a, a way of entertainment. Where you're only confined to use, what are the people doing in the rural sectors? Most of the time on these internet, on all these smartphones that we have, these are being misused. All these pornographic films that are being made day in and day out. The latest that we are seeing about the husband of this famous actress in Mumbai, whose husband has been booked for making pornographic films and putting them on apps.
So what's important is we have to utilize the best of technology. Certainly, you're making a right point. Let me go across to Mr. Malhotra for one concluding remark. So what Rekha ji suggests is, Mr. Malhotra, that we require a holistic approach which starts from education. Then obviously we require legal reforms. There is sensitization that is required, not only of the police, but also of lawyers and judges, because often we see there are bizarre remarks or insensitive verdicts that are pronounced against victims of sexual offences. But obviously towards this holistic approach, the most important aspect is we have to prevent such crimes. We have to ensure that women in our country are safe from being subject to such kind of crimes, and also if such events happen, to go and report them fearlessly. But where are we lacking? In over so many years, there have been changes, but the ground reality is we have still not been able to give women in our country a safe society.
I think Rekha ji has very rightly pointed out that for prevention of the crime, it is the awareness, advocacy, and education. All three are equally important, and they should be the first step. Having taken those steps, then obviously, if you really want the justice delivery and the expeditious justice or the fair trial, which are all part of the fundamental rights of the individual, then the legal system need to be strengthened. And for strengthening of the legal system, already as the government has taken certain steps, certain more steps need to be taken, and those steps include filling up the judges of the vacancies. They also need to be trained in the particular subject in which they are holding a special court. And they also need to be sensitized about the kind of trauma which the victim undergoes when a crime is committed against that victim. And therefore, justice delivery should be as fast, as quick possible. If that doesn't happen, probably the kind of result which we are expecting from constituting this special court, we won't be able to achieve. Sensitizing the society, that is of course the first step. Strengthening the law is another step. And enforcement of the law as expeditiously as possible is the most important part, so that it has a deterrent effect. It will have no deterrent effect, as we have seen, if there is a large pendency and if the trial itself takes years together for finalization. And even after the trial is concluding, at the appellate stage also, and the other stages which are available to an accused person to exhaust other remedies, that should also be made time bound to ensure that the victim also get justice and the accused, his trial is also not unnecessarily delayed. Because there may be certain cases where a person is booked where he has not committed an offense. If he has not committed an offense, then why he should face trial for 10 years? He should also come out of the jail within a reasonable time. But if he has really committed a crime, then the victim should get a justice by a time-bound trial.
Certainly. So timely and effective implementation of law is the key to obviously ensure fair and expeditious trial. That's what has come out of the discussion. There have been certain reforms that are needed to strengthen our legal system. That's been pointed out by both our experts. So with that, I'll have to call it a wrap on this edition of The Big Picture. Thank you once again to both my guests for joining me on the program and sharing their thoughts with us and our viewers as well. So that's it from us on this edition of The Big Picture. See you again same time tomorrow. Thanks once again.